Good afternoon to everybody. Can you hear me?
Yes. Good afternoon.
Okay, just 1 second. I have the usual problem. I don't manage to get the image here. Full screen. Let's see if I manage to get the full screen. Sometimes I'm not all that digitally able. So let's see if I manage to rename, spotlight, video, profile picture, hide sort view. No, this isn't it. Sorry, just 1 second. I'll be with you in a moment. Yes, okay. Now, what we'll start, did you receive the slides?
Yes.
Okay. Now, what we'll be doing today, tomorrow, and next week, we're going to sort of sum up, try to do some conclusive remarks on what you have seen in these well, I've counted them 1, 2, 3, 4, 5, 6, 7, 8, 9, and this is the 10th week. So we've been doing quite a lot in this time. What I'll try to do is put these things together in order that you don't have the impression that they are sort of separate blocks. I'll try to, as if you had various building blocks, and now we must try and do the building and see how it works and how it comes out. So today, tomorrow, and next week, we'll be trying to build a legal system. And I hope also to give you some kind of sort of, I don't know if it's amusement, but I'm going to put a sort of, I would like to do some kind of a contest, a prize contest. I have organized a puzzle, and but I'll give this to you tomorrow or the next day. Sort of, I've organized a legal system puzzle with prizes, but I haven't finished preparing it, so it'll be sort of sometime tomorrow or on Thursday. I'll be sending an email, a link. Now, what have we seen? We've seen these various aspects. Well, obviously the constitutions, fundamental rights, values, government, administration, and then we've gone into sort of private activity, regulation of economic activity, welfare state, and taxation and labor law, and then we've seen, well, criminal law, criminal procedure, the judiciary, the international sphere. So we've seen quite a lot of aspects, and now I'll try to sort of give you some ideas of how to build these things. Obviously, it's one way of presenting the system, and one can present it also in different ways. Just to point out that this is not, obviously, it's not a sort of a dogmatic approach. It's just one view of a legal system and of legal systems. And obviously, it's up to you gradually while you grow with your knowledge of the law. You have different perspectives which can change not only according to where you are placed. I mean, obviously, if we have Sylvie Shiu in Hong Kong, and well, she looks at recordings on YouTube, well, obviously, you would build a system in a somehow different way than what you would do if you are in Rome or in Liège or in London. Just to point out that this is, it depends very much on what is your point of observation. Having said this, let's try, I'll try to one second. Okay. Can you see the slides?
Yes.
Okay, just this is
Yes.
Every now and then I have my dots on the thing. So the first point I would like to make is that although, and especially Italian students, we have this idea that the legal system has a very long lifespan. I mean, we've all studied, and you've just studied Roman law, so this gives us a historical perspective and gives us the idea of what the roots of a legal system are, which is very important. Just remember that history is an essential element of any legal system. If you don't know history, you don't know practically nothing of that legal system. However, we should also take into account the fact that legal systems change over the ages, and obviously they don't change overnight, but they do change. They do change in long periods. We'll have to see to what extent the pandemic that has been going on for, let's say, 4 months, well, has it changed legal systems? Well, under certain aspects, yes, but are these changes significant and permanent, or are they just temporary changes? We've sort of had some difficulties for a few months, and then we will return to business as usual. Just to point out that there are some turning points in legal systems. Two typical turning points that we have repeatedly analyzed are the American Revolution, because that means coming out with a democracy and the idea of a constitution, and at the same time, more or less in the same years, we have the French Revolution, which means a different organization of the state and of how the law is presented. So there are turning points, and obviously we've seen also that after World War II, one important turning point is the idea of a welfare state, at least in Europe, and the idea that increasing intervention of the state in economic activities, that is regulation. So just to point out that but these changes are not overnight. They're slow, and then we have to assess if there are significant changes or if they are only superficial changes. We shall see some of these aspects in these last lessons. So just to point out, legal systems change, although they have some elements are still there and are historically there, and they will remain there, and they give the idea, the structure of the system. It can't, if a system has been created in a certain way, it is rather difficult that it changes completely. Well, yes, clearly there could be dramatic events in that sort of change the whole, but it's society that changes. It's not only the legal system. But otherwise, the changes are very gradual. So when legal systems change, obviously what we are interested in is obviously in comparing. When we do comparison, obviously if we were in the 18th century and we compared legal systems, we would have used certain criteria. Obviously in the 21st century, 4 centuries later, well, things are significantly changed, and also the comparison changes. So just to point out again, look at the historic development of legal systems and of how you compare legal systems. So what happens in the 19th century? Well, the whole idea was, well, there was only Europe was the heart, continental Europe was the heart of legal systems, and we were only looking at what was happening in Europe, in continental Europe, and then obviously we were looking at Latin America, which had followed sort of the European model. We thought that, seeing this from, obviously from continental Europe, we thought that there was no legal system, or very strange legal system in the British Islands, and we didn't really understand what was going on there, and so we kept it away and said, well, that's rather primitive legal system. We cannot compare it with ours. We are, continental Europeans are evolved, we are developed, and they are underdeveloped. Things were not at all like that, but this is what the impression that continental Europeans had. So at a certain point, towards the end of the 19th century, well, one realizes, and this is one of the main merits of lawyers who were studying commercial law, they said, listen, and they're doing, it isn't that in Great Britain and England they're not doing business. They have companies, they have credit instruments, they have financial institutions and so on, and everything this is organized by the law, so it makes no sense. We start saying, oh, but that is strange territory, unknown territory. We better study it. So towards the end of the 19th century, we see that one starts studying also the American and the British system. As a matter of fact, it was also vice versa. I mean, there's a famous British scholar, I'll write his name. Let me see where I find, sorry, just one second, just let me find my chat. Here we are. Okay, Dicey, who had a very sort of idea, you know, the legal system was only in Great Britain, and sort of on the European continent, they had very strange ideas, and the whole system was under some kind of bureaucratic and control, automatic control. So I mean, there were many misunderstandings on one side and on the other side of the channel. So finally, towards the end of the 19th century and then moving into the 20th century, well, continental Europeans started to study and understand what was happening across the Channel and across the Atlantic, and partially this happened also vice versa. In the US, this was due very much to the fact that, especially after the racial persecutions, the dictatorships that came took hold of Europe in the 20s and the 30s, and with the racial laws, anti-Semitic laws, a whole lot of brilliant lawyers, scholars from continental Europe of Jewish descent, both in Germany and in Italy, they all fled to the US, and therefore they influenced significantly, at least for several decades, the way the US looked at Europe, because they were very brilliant scholars, very with a great reputation, and they sort of brought into the US debate a whole lot of ideas that they had learned in continental Europe. So just to show that in between the end of the 19th century and the first half of the 20th century, well, sort of the two areas, big areas, continental Europe on one side and Anglo-American systems on the other side, they sort of got to know each other. There's still quite a lot of misunderstandings, but at least they discovered each other. Then what happens after the Second World War, second half of the 20th century, we start comparing, we start looking what's going on outside. Not that we didn't look what was going outside, but we weren't so, we didn't really have the instruments to, logical and intellectual instruments to understand what was happening. So we started studying more profoundly Islamic law, Far Eastern legal systems. So we try to compare our Western models with models coming from other countries. And then finally, in this century, 21st century, we say, well, that we should consider and compare legal systems in a global setting. The fact that the world is much smaller not in sort of geographical size, but in kind of relations, the geopolitical relations that exist. We should remember that from the end of World War II to practically the end of the 20th century, there was a part of the world that was westernized and pretty open, and then there was the communist part of the world, well, Soviet Union, its satellite countries in Eastern Europe, and People's Republic of China and its satellite countries, which was a huge bloc. And when this bloc dissolved, obviously the world became much more interrelated. And so this is what we've been trying to do in this class, taking into consideration the fact that legal systems are much more interconnected in this 21st century, and we must place them in a global perspective. So what are the effects of this globalization? Circulation of models. What does circulation of models? The fact that if societies often have common problems. Obviously, we are talking of developed countries. We have common problems, and how do we solve these common problems? Just think of something sort of an area of regulation which is sort of very important. Just think of telecommunications or energy. And obviously, if there's a model that is adopted in a certain country to regulate telecommunications, well, telecommunication networks and apparatuses and so on, well, it is quite probable that that model will be if it works, will be replicated elsewhere. Why? Because it works. It works, and it's a technical, these are technical aspects that need technical expertise, but also a certain kind of relation between who is regulating and the companies that are regulated. And so the models, and so we see models that circulate, and we look at, let's say, telecommunications law, and we look at this in, well, whether we're looking at it in the US or in Japan, in Europe or in Brazil, well, we see that more or less the model of regulation has circulated. And we've also seen, especially in, well, yesterday, we were looking at the regulation of financial markets and sort of the Bank of International Settlements and the Financial Stability Board, and we see that the rules they come out with, hard rules or soft rules, it doesn't matter, they somehow are imposed themselves around the world. So we have a lot of legal solutions that are exported. There's a country that exports models, and then these models are transplanted, they're imported and transplanted in other systems. A good example could be the European Union data protection legislation and how it has been adopted in other countries, non-European Union, for example, in Latin American countries. Just to show you that it is the fact that in this globalized world, it's not only goods that circulate with great facility, not only services that are provided all around the world, whether financial, insurance, transport, or other kinds of services, professional services, but also legal models, legal solutions to economic and social problems. So we try to transfer them from one, to export them and transfer them from one country to another. If we look at the solutions that are given in these, have been given in these last 2 months to the pandemic, to the economic and social problems posed by the pandemic, or even practical problems, just think of hearings in the courts and so on, well, we see that there's a lot of, many of these solutions are replicated. So very strong circulation of models. Obviously, these models are adapted to each country, but you can easily recognize, a comparative recognizes, hey, that's a model that is, they started in that country and then rapidly it went to other countries and it is adopted in other countries. So when we're looking at sort of while in the in the 20th century, before a model was exported and transplanted, well, it took quite a lot of time, sometimes decades. Now we see it often, this is very, very fast according to depending on the circumstances. Obviously, now we are in a difficult situation, economic, social, financial, political, geopolitical, and well, and the models pass very rapidly from one country to another, how you decide, procedures, and the content of what you decide. Just to show you that this is typical of our contemporary society and our globalized world. So this is the first point I wanted to make, just to show you that when we talk comparative legal systems, what are we comparing? If this class, when I started teaching in the 20th century, obviously what we were comparing were certain aspects. Now, 30 years later, obviously we are comparing, isn't it we are forgetting what we were comparing before, but we are looking at at new aspects and that should be and that deserve to be compared. Now, let's just to remind you, and this is a great advantage for Italian students, and they should never forget it, but also
generally continental European students have this very clear because this is part of their legal education. In other legal systems, this aspect is less considered. Always keep in mind the historical evolution of the system. If you know what the evolution of the system is, you know where it came from, and where it reasonably will go. It is rather difficult that suddenly a system will overturn. If it has taken a certain trajectory, well, it will follow that trajectory. It can have some slight adjustments, but it will, once we know the history of a legal system, well, we know more or less how it will evolve. Now, the same thing is with comparative law. We can't just sort of think that as the world has changed, we're going to throw away all what we learned in the past. What have we learned in the past? I'll just focus on a few aspects which deserve to be. Let's see if I manage. Yes. Okay. Now, just to point out what I call a few historical stepping stones in comparative law. Comparative law develops mostly in the 19th century and then goes on obviously in the 20th century and now. Now, the first point that I would like to make is that it's very common to make this distinction, and you will find it regularly among lawyers who have not really studied comparative law, and they will talk about this common law and civil law distinction. Common law means England, Great Britain, well, US, Canada, Australia, New Zealand, and civil law, more or less the rest of the world, more or less. Well, this distinction requires, in this class, obviously, comparative legal systems class needs to be clarified, otherwise you may end this course with some doubts or some misunderstandings of what we are talking about. So, first of all, you should learn this. Obviously, our British students know this very well, but this is not our continental European students are not educated in this area, that the term common law has three historical meanings, which are quite different. The first is in the Middle Ages, when the Norman kings, England is conquered by the Prince of Normandy, William the Conqueror, in 1066, at least that is the date, the founding date, the Battle of Hastings. And the Normans, who are incredibly adventurous and very well organized. Remember, Normans came from the north and they occupied Normandy, and then they conquered England, but had also gone down to Sicily and had chucked out the Arabs from Sicily. So just to show you, pretty adventurous, and but they were very well, they had an idea of how to organize a state. And so when Normans occupy and conquer England, well, they set in London, they organize their new state in their capital, London, and one of the first things they do, they set up courts to decide cases. And so these courts, what do they apply? The rules that the Normans have brought with them from Normandy, which is a mixture between, partially, traditions, traditional law, customary law, but also with some elements of Latin, and they use French, this rather barbaric French language. And so common law is the law that is practiced in London, in the King's Court, London, as opposed to the law that is still and will still for at least a century and a half be administered in
local sort of and rather traditional, I wouldn't call them courts, but anyhow, places where they take judicial decisions in parts of England which are still under the Saxon and the Dane influence. The main occupiers of England after the fall of the Roman Empire come from Germany and from Denmark, so Saxons and Danes. And so, just to say that common law means the law of the whole kingdom, and not traditional, regional, local traditions which are administered by local, let's call them local courts. So that is the first meaning, and to show this is the law of the whole kingdom as opposed to local tradition. The second meaning of common law is bifurcation of jurisdictions, in the sense that the king creates his courts in London. These courts progressively become independent from the king. It isn't that completely independent, but they are somehow more independent through this play between the barristers who then become judges, and the legal system that develops in the courts. But however, the king still, as the king, as you know, in medieval history, is someone who's been, who is sitting on the throne for grace of God. He has the power to administer justice. And therefore, the king, English kings, continue to administer justice through their chancellor. The chancellor, who is generally someone until Henry VIII, is until when Church of England is created, is someone who's an ecclesiastical, someone who comes from, who is a bishop or some other religious, Catholic, obviously, high priest, and the chancellor in the chancery, and this is still called like that, is sort of court of equity. So we have the courts of common law and the courts of equity. And if you and our British students know very well, generally in English language now we talk of remedies at law, that is at common law, and remedies in equity. And now the jurisdictions are joined together since the end of the 19th century. But this is a second meaning. So we have courts of common law and the courts of equity, or rather the chancery. So this is a second meaning. The third meaning, which develops in the 19th century, is this very clear idea of the common law systems as opposed to the civil law system. And the civil law systems are those of continental Europe. So just to show you that when we talk, obviously if you go to you come to a comparative law class, well, you should come out of it knowing that the term common law has many different meanings, historical meanings, and when we talk about common law versus civil law, well, now in a moment we'll see that this is, well, an idea that sort of this opposition of the two systems, well, it is an idea that was developed in the 19th century, but today is not very reliable. We'll see this in a moment. Let's see if I can. So, civil law. So we see common law system, civil law system. Now, civil law is a shorthand invented by British lawyers. It isn't invented by us continental Europeans, because obviously civil law is an English term. It's invented by British lawyers somehow to indicate continental European legal system. What do they see from the white cliffs of Dover? What do they see across the Channel? They see the nearest country, which is France, and which is way away, away, also because it's been very fierce enemy historically. France has always been an enemy of Great Britain since Middle Ages. So, I mean, it's not something new and of late in those times also Napoleonic wars. So what do they see? They see the legal system, what is the main aspect in the legal French legal system, the civil code. And this code civil, well, they say, well, these are systems, civil law systems. And this is a way to put everything together. They keep everything together, whether we're talking of France or we're talking of, or we're talking of Germany, whether we are talking of any part of continental Europe. For British lawyers, it was, well, civil law countries. And still now the idea is, well, they're civil law countries. And continental European and obviously Latin American countries, which means Latin America from Mexico to Chile and Argentina, so huge subcontinent. So just to point out, this is the idea that that English lawyers have of the European continent and say, we are common law, they are civil law, and this between us, there's sort of no way of communicating. So misunderstandings on not only on the European continental system, lawyers who do not understand what's going on in England, but also in England, they don't really realize what's going on the European continent. So now what happens is that generally in the legal language, we use sort of common law to indicate Anglo-American legal systems, and we use civil law, civilians, to indicate European legal systems and their imitations. It's just a shorthand expression, just as we say Americans, as if sort of, well, as if Canadians or Brazilians are not from the Americas. When we say Americans, well, we mean citizens of the US, of the United States of America. While if we want to point out someone who comes from Canada, Brazil, we say Canadian, Brazilian, Peruvian, Haitian, or something like that, just to show that we use words in a very simple, oversimplified way. Now, what is the idea, the basic idea behind this distinction? And I tell you that I will repeat 100 times, that this distinction has lost much of its importance. The idea that the common law systems, the law is made by the courts. So this is what the English, American lawyers feel, that the law is made by judges, judge-made law. And this is also what the continental European lawyers think. They look at in the 19th century, they look what's going on in England, they say, oh, but where? They have no codes, they have, this legislation is insignificant, everything is in the courts. So they think that all the sort of legal factory is in the courts. And at the same time, the common lawyers, Anglo-American lawyers, they look on the continent and say the only factory of the law is Parliament. And so the only institution that makes law is Parliament, and Parliament then prepares these nice packets, puts everything in a big packet, which is called a code. And so the system is a code. So they have, and they have this idea, which is quite sort of common still now in Anglo-American scholarship, the idea that the sort of somehow the code is some kind of computer program that you just press article 1218 or 2043 or whatever, and you press a button and out comes a decision. Well, we know that this is not, this doesn't happen like that. Obviously, we have, the system is organized, the code is an organization, but of the legal system, but things don't work like that. Just as the only source of law in Anglo-American, in the Anglo-American systems are not the courts. They're not the only source. At the same time, if we look at continental European systems, well, parliaments are not the only source of the law. Go back to that slide which I gave to you when we were analyzing jurisdiction, what we mean by law, and we see that the law is obviously primary sources, sub-primary sources, regulation. We have court decisions taken by the courts or other dispute resolution bodies, and then we have social practice, social norms. So in legal systems, we see that today, 21st century, in the Western tradition, we see that the sources of the law are many, and they are not only those that in the end of the 19th century and most of the 20th century, lawyers from one side or the other side of the Channel or the Atlantic saw in their opposite, in the system that were opposite to them. So just to point out, repeat, this distinction between common law systems and civil law systems is valid from a historical point of view only for private law and criminal law, in the sense that we see that in England, well, surely if we want to do a history of private law in England or criminal law in England, well, we have to go through the decisions of the courts. Well, we do find a certain amount of statute law. Statute, that means laws enacted by Parliament, but mostly we will look at the decisions of the courts. This distinction, if we want to really look at historically the sort of the distinction between common law and civil law systems, well, it would apply only to private law and criminal law, which are very important aspects of law, but do not cover all the systems, and in fact, all the aspects of a legal system. Because the distinction between common law and civil law makes no sense when we look at constitutional law, or when we look at administered law. For example, the US Constitution is the model for most continental European constitutions. Obviously, we elaborate, we do much more complex constitution, but we have the idea of a written constitution, which is at the pinnacle of the legal system, and we've set we have these two legs of a constitution. We have the partition, separation of powers, that is legislative, executive, and judiciary, and then we have fundamental rights. So we have these two legs, and we follow the American model. So from that point of view, we see that the American system and the continental European systems are very much similar than they are with the English system, the American system with the English system. So it makes no sense saying common law systems putting together from a constitutional point of view, putting together Great Britain and the US. From a constitutional point of view, there are two different systems, significantly different systems. Then they have obviously common values, but the systems are very different. So we are, as constitutional, when we look at constitutional law in continental Europe, and we were naturally brought to look at what the US Supreme Court is doing, how it has interpreted certain clauses of its constitution, whether it concerns powers, separation of powers, the federal government, or fundamental rights. We should look at US Supreme Court. We will not look, or we will look much less at British courts and the UK Supreme Court. Just to show you that from that point of view, from constitutional law perspective, distinction between common law systems and civil law systems makes absolutely no sense. The second aspect, administrative law, and we know that administrative law is so important. It's not only how administration is organized, but rather much more how administration organizes society. It regulates economic activity and social activity. Well, nowhere in the world, whether it is in Great Britain, in the US, in Canada, Australia, New Zealand, Germany, France, Italy, Spain, or Romania, administrative law is not judge-made law. It is pieces of legislation set by Parliament and then sub-primary legislation set by government. So just to point out, as you can see, this distinction starting to say, well, there's a common law administrative system, well, makes really no sense if you start comparing how an agency works in the US, in the UK, or in Germany or in France. Well, you see that these agencies work more or less in the same way, and they produce rules in the same way, and the content of the rules are more or less in the same way. And then every now and then, there's some decisions by some court, but it is not the decisions of the court that shape the law. The law is made by Parliament, by Congress, and the administration and the administrative agencies follow what is said by Parliament and by Congress. Again, just to show that this distinction is a distinction which is useful, just shorthand, just to say, well, common law countries, but we know that they're sort of just to indicate some part of the legal geography. We call them common law countries, not to say Great Britain, rather England, and well then the US, Canada, Australia, New Zealand, and then the rest of the world. So we use this as a very simplified expression. As I've already mentioned, we see that in the Anglo-American system, there's an increasing role of legislation, primary legislation, that is, rules set out by the legislative body, whether it is the UK Parliament or the US Congress, and at the same time, so that shows that there's not all that different the role. It isn't that they ignore primary source of the Parliament as a primary source of the law, and at the same time, anybody in his right, any lawyer in his right senses in a civil law jurisdiction cannot just look at the piece of paper, what is written on the text, and say, oh, but this is what law says. Now, this is someone who's not a lawyer. A non-lawyer will look only at the black letter rule and say, this is the law. A lawyer will say, hey, let's see how it's been interpreted and applied by the court. So we see that in continental Europe and in civil law countries, lawyers spend much of their time looking at case law as an American lawyer. Same thing, we follow the same way to understand what the law means and how it is applied. No lawyer, one side of the Atlantic, one side of the Channel, and this other side of the Atlantic or the Channel would ignore, on the one hand, legislation, and on the other hand, would ignore case law. So we work on these two aspects together. And also, we should take into consideration the fact, as I've mentioned, when you talk about private law, that is the law that regulates legal relations between private individuals, obviously the development of this in England has been through very long, slow process of the courts. But now what happens is that, as we've seen, economic activity is mostly regulated not by the courts, but by government through administrative acts. through administered agencies. And so when any enterprise wants to know what he can do, what he cannot do, how he should do it, it doesn't look at the courts. It looks at the regulatory, huge amount of regulatory system, and somehow complies with those rules. It doesn't look at what the courts say. So the fact that the private law, or rather the regulation of economic activity, has moved from a laissez-faire, from a sort of a very free freedom of economic activity approach, has passed to a much more regulated approach. So nobody would look at the courts, or they would look only occasionally at the courts, and they would look much more to independent agencies, who imagine competition authorities, financial markets authorities, or look at what the international institutions have been doing. If I'm a financial institution, I will be very careful and see what the Basel Committee on Financial Stability, on banking regulation have set out. So I look at that. So an international organization, I'm not going to look what the courts say. I'm going to look what the international organizations have been established. So just to point that this, so when you hear, you will be hearing this idea of, you know, civil law, common law, well, take it with not a pinch, but a handful of salt, and know that as you've taken a comparative law class, well, you know that this is a very oversimplistic approach of dividing legal systems. And at the same time, this idea that in the Anglo-American world, they have the idea that the system was in continental Europe is all organized in codes, and somehow codes are siluses in which you stack in all the law, and then you somehow it's all organized. Well, codes have a very important role in the evolution of legal systems in continental Europe. It is one of those other products, extraordinary products of the Enlightenment and the idea of legal reform. The idea that the law should be simple and easily accessible in one comprehensive text. So this is an idea that is obviously it is opposed to the way the legal system developed in the Middle Ages and went on well into the 18th century, that it was really very difficult to find the sources of the law and to understand what was the law, because you had an enormous amount of text and they were completely non-organized, and there was no priority. You didn't know who had enacted certain rules, or if one source of the law was superior to others, and so on. So the whole idea of legal reform in the 18th century is put in order in the legal system, and put in order from a lawyer's point of view means put in order from two factors: the position of the source, the highest source commands the lowest source, and secondly, the time factor. Subsequent law, the most recent law, substitutes the, unless it is expressly established differently, the previous law. So these two factors, the position, the hierarchy of the source, and the time in which the moment in time in which this piece of legislation has been enacted, this somehow should aid establishing what is in force and what is not in force. So this is very basic ideas, and as you see, they're mostly logic ideas of logic, how you organize various various ideas, legal principles, how you put them in order. And as a matter of fact, if we the whole idea is that of bringing to certainty of the law. So when the law is certain, well, if it can be known, so if all the subjects, obviously we're talking about the 18th century before democracy, they weren't citizens at that time, well, the law must be known. Obviously it can be known if it is written, and it must be written in a certain way. Therefore, it must be logically organized from general propositions, special rules to exceptions. This is somehow the idea, a mathematical idea. This enormous role was given to this by this genius, this 18th century, 17th century genius, Leibniz, German lawyer, mathematician, diplomat, whatever. He knew everything, really, a real genius. And he applied, I mean, he's one of the inventors of digital reasoning, we still use his idea of development of a digital system. That is two digits, that means 0 and 1. Well, that comes from Mr. Leibniz in the 18th century, beginning of the 17th century, of the 18th century, 17th, 18th century. So the idea that the law should be organized like a mathematical system. Therefore, there must be logic behind it. So there are general propositions, theorems, and then you have obviously the consequences of these propositions. And so the best model is obviously the 5 Napoleonic codes. 1804 to 1811, Napoleon, with his strengths, with his will, imposes and forces France to modernize all its legal system and introduces these 5 codes. And so we have civil code, commercial code, code of civil procedure, criminal code, and code of criminal procedure. And you see there's a copy I have, because lawyers generally, sort of anybody in continental Europe has at least somewhere these codes among the precious books of his or her tradition. Well, there you see the 5 codes published. If you look at you can see here 1811 just immediately published in Paris, and it is a booklet. It's somehow a pocket book, 645 pages. So the idea is that you wanted the law, here you have all the law in 5 codes in 645 pages. Now, this was an illusion. It wasn't really like that. There was a whole lot of law that was left out. But this gave you the idea of a legal order. You had 5 codes. There was this great man called Napoleon that had imposed these 5 codes, and the legal system was organized. This is obviously an intellectual view of the codification, but it is very powerful because it is a very powerful idea, and this is a model which circulates and is strong for at least the whole 19th century and well into the 20th century, this idea that you can put all the law all together, organize it in a comprehensive and understandable way. I mean, you find that if you have 5 codes there, well, you have any citizen can have the whole legal system at within his or her reach. So just to point out that this is very enlightenment idea, and this idea that the law must be niche to grasp and anybody should be able to understand. So just to show you that this is a very strong idea, this idea of code. However, what we see is that codes have, so surely they are a model of organizing legal system, and continental Europe follows this model, and Latin America follows this model. And so we continental European lawyers, when we go into Argentina, or we go to Peru, or we go in other countries which are somehow Russia, well, we find ourselves at home because we know we find their code similar organization of parts of the law which are very similar to how we organize it in our home country. However, what happens after World War II? What do we have? Fragmentation of interest. I mean, the private, the civil code was a representation of private interest of individuals in family laws, successions, property, and their ownership, and so on, and their individual contracts. And then there was commercial codes, which mean business activities. Now, what happens after World War II? It's a fragmentation of interest, and that means that sort of everybody who has interest, or each sector that has interest, creates, well, brings to the decodification, in the sense that these codes, these 5 codes, considered so important, then they are somehow decent, they're no longer central to the legal system. They have a much less important role than they had in the 19th century. So starting from the second half of the 20th century, their strength is somehow, just imagine a castle, well, the walls of this castle have somehow fallen down. And what you have for each of the economic sectors, you have a whole lot of regulation, which is set by government. Government sets a certain amount of regulation of sectors, of economic sectors, and all these pieces of legislation to give an idea that it's orderly, but they're very disorderly. They call them codes. And so we go around the world, and we find construction codes, privacy codes, telecommunication codes, consumer codes, and so on, anything, whatever code. So when you want to give the idea that there's an important piece of legislation, you call it a code. And also, it's not only in continental Europe that we use this term, but also in the US. You will see that there's a US code, which is the whole system, all the laws of the US are in this US code. Quite impossible to find them. I mean, you need, so now we have digital search engines, and so we can do a query and we find this piece, but otherwise it's quite impossible to find. Or we have this uniform commercial code, which is about 20 articles, so nothing to do with a sort of continental European code, but we call it code. So just to point out that this is sort of how systems have evolved, and why in the 21st century certain ideas that were very strong in the 19th century and developed mostly also in the 21st half of the 20th century, now they're not of all that great significance. So just to point out that this is sort of first aspects that I would like to point out to you, sort of the stepping stones, a few of, now we'll see another stepping stone of comparative law, but I will do a break here, and as usual, ask you, sorry. Any questions on this first part of the lesson? Sorry, just sort of sometimes I sort of maybe I go too fast and sort of skip certain. Okay, apparently for the moment, apparently I don't see questions, but if you have other questions, I'll try to answer them in the rest of the lesson. Now, so we've seen two sort of stepping stones in comparison. So this civil law, common law distinction, which we've seen that historically makes lots of sense, today makes much less sense. And we've seen the role of codification, which is a fundamental page of the development of history of the history of law in continental European systems and many parts of the world, but again now much less central because there's so much special legislation, but not only in private law regulating private economic activity, also in other areas. Just think of criminal law. Just think of very serious crimes such as drug trafficking, money laundering, modern forms of slavery, exploitation of women, and obviously international crimes against humanity. Well, all these, you would find these really in the criminal code. You will find legislation, specific legislation, which is there to combat these very serious criminal phenomenon. So just to show that even in an area which seems to us a fortress, that is the fortress of the strength of a state, that is of criminal law, well, we see that the criminal code in those countries that have a criminal code, well, it is important, but much of the very much of the important criminal sanctions and criminal provisions are outside the criminal code. Now let's move, just move back to the slides. Now, what are we trying to do here when we are sort of organizing legal systems? So we said that, well, you know, it's, I said civil law, common law distinction, which is a very sort of something that has been used for well over a century. Well, it's obsolete and doesn't make much sense in this global world. What happens in the second half of the 20th century, there are some comparatives, especially important French comparatives, comes out with the idea of legal families, which is a nice and amusing metaphor so that they are legal families. So we find various families of law, and these families, obviously their fathers, their grandfathers, then the parents, and then they have children, and then they have grandchildren, and they have some kinds of relatives. And so the idea of a legal family gives you an idea of you know, legal systems that are somehow related from a genealogical point of view, that are somehow related because they have blood relations there. While other families, obviously these other families are quite different, and they are different families and they do not intermingle. Now the problem is with this metaphor worked very well when we had the idea that a family was a man and a woman, and obviously, and they married and they had children, and that was the only marriage in their life, and that was it. So it was very simple. Now, if we want to use the metaphor today of families, of legal families, well, we look at what a family is today, and we see that they're same-sex families, and so, well, and that and orphan people, well, get married maybe once, twice, 3 times, or they have extramarital offspring, so they're children that are born out of wedlock, and then obviously you have adoptions, and then you have artificial insemination and whatnot. So this metaphor of the family, which worked pretty well in the second half of the 20th century, today doesn't work all that well. And as a matter of fact, when we look at this distinction that is we find in many sort of 20th century handbooks, civil law family, common law family, and there was a Scandinavian family. So they were different. So they were tall, blonde, blue eyes. They were nor civil law, nor common law. And well, we say, well, Scandinavians, well, whether Finns, Swedes, Norwegians, Danes, and Icelandic, well, we put them together and we could say that they are Scandinavian. And so that's another family, and then mixed systems, and then you discover that they're mixed systems. What is South Africa? South Africa, well, they were the Dutch, who are sort of civil law, but then the British came down, the whole system is somehow mixed up, and you don't know, or you find Louisiana, Scotland. I mean, Scotland is a typical mixed system because the Scots, owing to their opposition to England, always were looking to continental Europe and therefore followed a whole lot of ideas that came from the continental Europe, noticeably Roman law. And then socialist, before the fall of socialist countries, there was someone who would put together the idea that there were socialist legal systems, because you see this in ideological aspect, and then those who put together legal systems on the basis of again, not ideology, but religion, so Islamic systems, and then the Far Eastern, just simply because they were Far Eastern, so they were China and Japan, and then we had obviously primitive legal systems, the Amazon forest, equatorial forests in tribes living in forests in the Amazons or in Africa or in New Guinea, and so primitively. So trying to sort of place and organize legal systems according to these classifications. Clearly, classifications are useful in as much as they help us understand and they reflect in some way what is reality. If we look at what reality is today, 21st century, we see that these families are sort of do not present much appeal because they are not able to describe what's going on in the world. Let's see if I can. So this classification according to legal families tends to be simplistic, and because best example is if you look at some areas of law, you find common rules which are substantially applied in similar ways. Mostly regulatory law, which regulates economic activities, financial systems, telecommunications, energy, transport. Well, we see mostly whatever the legal system. The Central Bank of Iran and the control that the Central Bank of Iran, of the Islamic Republic of Iran, has over the banking financial system is not all that different from the kind of control the Bundesbank, the German central bank, has over the German banking system. Obviously, two countries are significantly different, and the role of banks is significantly different, but the rules more or less are the same. They're two worlds apart. You can say that obviously there's no relationship between the Islamic Republic of Iran and the Federal Republic of Germany. But when it comes to regulation of financial sector, well, the system is more or less the same. Or you find countries which are neighboring countries, which have the same, somehow similar aspects, but then you find very significant differences. They can be differences in how the institutions are regulated, federal state versus centralized state. Federal Republic of Germany, Länder, the regions, which have a very strong power. We've seen it in regulation of the, somehow in this pandemic, and what the role of the German Länder is in somehow countering the pandemic, and the centralized state, neighboring state France, which is still very centralized, in which all decisions are taken by the center. So just to point out, neighboring countries, apparently they should be quite similar. No, from this point of view, they are quite different, or the differences from very sort of apparently sort of impractical aspects, sort of buying or selling a house in Italy and Austria. Well, the procedure is significantly different. So just to show you that, you know, we have to sort of distinguish. We have to try to understand, what are we talking about? What part of the law are we talking about? And then we can look at similarities and differences. And these similarities and differences depend partially from what is the object, and part from traditions, from historical events, and so on. So just to point out that this sort of put in everything, saying that belongs to that family, that country, that legal system belongs to that family, and that other legal system belongs to that other family, is no longer a way to understand how a legal system is organized. What we can say is that surely there is a significant difference between historical and still present difference, actual difference between Western legal systems and non-Western legal systems. Obviously, we are Westerners, and so we tend to somehow, we look at ourselves, but this is useful somehow to understand what are the differences with other systems. And as you see, if you look at the slide, I put non-Western legal, I put it between brackets, because, well, the whole idea of law, for us it's obvious. We're talking of law, and something we immediately understand what it is. But it is a typical Western notion. This idea of law is full of these three words are full of a whole lot of ideas and concepts and history and notions that it is you need thousands and thousands of books would not be enough, because you have on one hand sort of religious and ethical elements which come from the Judeo-Christian tradition, which are the basis of the Western world, how the Western world was created. And on the other hand, we have this philosophy, first Greek, obviously Socrates, Plato, and Aristotle, and then all Roman philosophers, and everything came after the Greek and Roman tradition of philosophy. And all these things are embedded in the notion of law. You just see these three letters, and you open these three letters, and you find sort of thousands, 25 centuries of history at least, let's say 30 centuries of history of religion and of philosophy. And this is all included in the term law. What we mean as Western law and other civilizations do not mean in the same way. And what are the basic ideas that we Westerners have developed over these at least 30 centuries, not more? The first is that the law is made somehow related to individuals. So the whole idea is that we have at the center of the system, gradually, at the center of the individual, of the system, we have individuals. Whether it is Adam or Eve, or we have common day, Mr. Jones and Mrs. White, we have individuals. Rights, subjective rights, what in continental Europe we call subjective rights, fundamental rights, human rights. So it is an individualistic legal system. It is based on individuals. We're looking at rights of the individual. Obviously, community is important, but we will focus mostly on the individual. And the second element that is fundamental is this idea of justice. Now, you find it in the Declaration of Independence, justice for all, US Declaration of Independence, 1776. This idea of justice, which means our idea, our Western idea of justice. So the law requires somehow justice. If the law is violated, there must be justice. Justice that is rendered, justice that is administered. And this justice is obviously impartial, because otherwise it isn't justice. It is independent, the third party, the judge is a third party. It is proportional. It is also, well, this understanding in this idea. Just think of, I suppose you're familiar with the famous judgment of King Solomon. And King Solomon, well, as you know, the two women and who go in front of King Solomon, and during the night, one of the two children has died, and they are quarreling about live children, each saying that that is their own children and own child. And King Solomon says, well, it's easy, very easy. I'll just get a sword and cut the child in half and give you half of the child for each, and so you're happy and content. And so one woman says, yes, okay, that's fine for me. And the other says, no, I prefer you give it to that other woman. And then Solomon says, well, that is the real mother, give it to the real mother. This is, I mean, this in this history that comes from the Bible, this judgment of Solomon, which is, you find thousands of paintings representing this judgment of Solomon. This is the whole idea of justice. It's not only the fact that there's a judge who is deciding the case, but this judge puts reasoning and looks at the individuals and how there's mercy in in how he administers justice. So just to point out that these two notions, law and justice, how we have developed law centered around the individual, not around the community. It is around the individual. So everybody has rights, even too many rights, enormous amount of rights in the community, and society has much less rights, and at the same time, the idea of justice. Now, this is basic idea of Western legal systems. This is obviously the result of at least 4 millennia, more or less, of development of society, of ideas, of social habits in the world, in our Western world. We don't find this in other parts of the world. They have different histories, but they're not centered on individuals. They're much more centered on community or on transcendent aspects, and this idea of justice that we have. And it is part of our feeling when we talk that this is an injustice. We have this idea there's been injustice and therefore there must be redress for injustice. This is typically Western and does not belong to other civilizations. I'm speaking of civilizations, so very important civilizations that do not have this background, this historical, cultural, intellectual, philosophical, religious background. So this is first distinction that has to be made, and then we will make other, further on, we will make other further distinctions, trying to understand what are the characteristics of Western legal systems as compared with non-Western legal systems. But for today, I think we can stop, and I just wanted to know if there are any questions on this, on today's lesson. Any questions on today's lesson?
Sorry.
Yes. Who's speaking?
Adimari.
Yes, Adimari.
I didn't really get the evolution from the sunk code to the modern right.
Well, what happens is that clearly in the Napoleonic view, which is obviously the view of that times, well, the main areas of the law are private law, civil, that is relations between private individuals, commercial law, we've seen how that means commercial contracts, companies and instruments of credit, and also insolvency, and then we have obviously the procedures. So that is the idea that you can organize the areas of the law are somehow very clearly set: private law, commercial law, criminal law, and then you have the procedures. And so you organize the legal system in this way. What is what changes in the 20th century? What changes significantly is the fact that the role of the state is much more increasing, and economic activities cannot be regulated only through the civil code or through the commercial code. I'm just making a very simple example. So the economic system is so complex that you need special regulation, and we've seen the reasons of regulation is because all the enterprises that are working in a certain sector want some specific rules and try to find some specific rules to sort of organize their activity. And therefore, this is what significantly changes and brings to the result of what we call decodification, starting from the sort of the more or less the 1970s of last century. We have this long process of loss of centrality of the codes. I hope this is clear. Now, there's Ribi, who's regarding the exam. Will the procedure be the same for all 3 dates? Yes, the procedure is exactly the same. The exam, the content of the exam will be different. The possibility to come back in class, you mean to be in presence? No. For what we know is that, as a matter of fact, they're even talking of having this kind of exam also in September. So I have, obviously this has not been decided for the moment. What has been said by Roma Tre University, but also by Turin University or Palermo University, is that at least the exams of June and July will be done in through digital platforms. So that's sure. That's that is for sure. And most probably also in September we have the same procedure. So this is. I hope I've answered this. This is at least for what I know. And so hopefully I do hope we get back to class in October next semester. But exams in September will be. When is the last lesson? Jonathan is asking. Well, I was thinking of finishing lessons next week, next Wednesday. Sort of I'll try to So it's still tomorrow and next Wednesday. So that is next Wednesday means the 20th of May, which was expected date for finishing the class. Also because remember, for our Italian students, this is a 9-credit course, and so it is at least 72 hours. So this means it makes sense finishing next week. Any more questions? Well, if there are no more questions, please, those who joined the lesson after, I saw you, we were quite a lot, we were 45. Can you please just, those who joined the class after 5:05, just write their name down so I can just know who's here. Yes. Managed to do at least 30, but for the last 15, I saw many students who sort of came back to class, and I welcome them there, but I won't make their names, but that weren't present in the last week at least, or 2 weeks, and they're back in class, and I welcome them there, and I hope they'll keep in class till the end of the course. And just to tell you one further final information, I've practically finished the instructions for the exam, on the line exam, so I hope, if it's not tomorrow, in the weekend, to send you these instructions, just to be, so you know already how the exam will work and more or less how it will function, how the exam will work out. But I'll be sending you this on soon, very soon.